Chairman and honorable colleagues. I am presenting a bill today, House 5755, the estate tax lien discharge bill. An issue was brought to my attention at some point over this summer, and it seemed that it was something that could be legislatively dealt with rather easily. I am by no means a subject matter expert on this. However, I have the good fortune of having someone here who is. We are essentially engaging in a process with regards to what's commonly referred to as the death tax or our estate tax that appears to be extremely overcomplicated. And that is about as far as I'm going to go, and I will defer to our witness at this point.
Okay, thank you very much. Welcome aboard. Just give us your name and a brief testimony of what the bill is about, please.
Hi, my name is Julie Aldrich. I am a real estate paralegal, and I'm speaking from the behalf of the Rhode Island conveyancers. When we do real estate closings, part of what we do is a title search. When someone dies in Rhode Island and they own real estate, there is an implied statutory tax lien, the estate tax, that immediately attaches to the property. Our job is to make sure that the clear title conveys to the buyer. Closings come to a screeching halt when someone has not filed an estate tax return. And the reason why they don't get filed is because most people don't realize that they need to. So in a situation, say husband and wife own property jointly as tenants by the entirety, one spouse dies, the property automatically conveys to the survivor. That survivor doesn't know that they need to file this form. So we go to the closing and it comes to an immediate stop because now we have a cumbersome process of the seller now having to pay a professional, a CPA, or a law firm to gather the information, complete the estate tax return, pay $50, send it into taxation, and wait, and wait, and wait for the discharge to be issued. And in the meantime, the closing can't happen. So the buyer's screaming, the seller's screaming, the realtors are screaming, the lender wants to know what's happening, and we can't do anything about it. And there is a very simple, easy process that this can be handled. As in Massachusetts, if we take a cue from them, if you are under the threshold of the minimum tax estate, I believe Rhode Island is $1.65 million. If you are below that in your estate, your executor, your administrator, or a person in possession of the property can sign an affidavit saying no federal tax is owed, no tax return is due, there is no tax, here is my affidavit, we record it in the land evidence records, no estate tax lien, it's gone, and everything can proceed. But that's not how we have to do it here. We have to go through a very lengthy process in order to get that taxation to process the return and issue the discharge. And while that's happening, no one's getting paid, commerce is being stopped, essentially, and sometimes the real estate dies. The sale goes to the wayside because the buyer can't wait, or the seller gets frustrated, or other factors come into play where if there's a back-to-back-to-back kind of closing, everybody's closing gets killed. So we could do it very easily by just having an affidavit signed and recording it, which would discharge the lien, which is how it's done in Massachusetts.
If I may add on to that, we have essentially what's called the RI 706, which is a tax form. It's a very long, complicated form. And we require everyone, even if they are below the threshold for the maximum tax, to fill that form out. Massachusetts does not. They say attest under the pains of penalty and perjury that this is true and accurate, and you just pay the same fee, and it goes forward. So I asked, naturally, when Mrs. Aldrich brought this issue to me, I said, it seems like the attorneys and the accountants would be getting a lot of work out of this, and you know me, I'm a cynic. So I said, why would you want to stop this? And the reasons were just because they are holding up. And if they're holding up everything in transactions. And if you do have Mrs. Smith who passes away 6 years prior to Mr. Smith, there are some times where Mr. Smith at that point will have to go back and reconstruct 6 years' worth of tax returns. And that's a burdensome process. It's an unnecessary process from what what I've learned and I understand. And as I pointed out, as we try to emulate Massachusetts here in the State House when they do things right, and they don't always do things right, in this case here, they do. A simple form. You sign it, you attest to it. If you're over the limit, you fill it out. There's no reason why we shouldn't do the same thing here. It would not impact our revenue from these forms because they would still pay the $50, which is what they pay for the filing. They just would not have to pay a lot of money to accountants and attorneys. And I think we all can agree that's a good thing.
And just to add to that, I've been a real estate paralegal for 33 years. And in 33 years, I've had 3 that actually resulted in a tax.